Today, we're tackling one of the most misunderstood estate planning strategies in Canada, putting a family member on your bank accounts or real property as joint with the rights of survivorship. On the surface, it seems kind of simple. Let's avoid probate, let's keep things simple, let's make life easier for the kids after we're dead. But the truth is that the strategy to put somebody on as a joint right of survivorship might create more risk, more conflict, and more legal and tax exposure than had been otherwise present. In fact, it may create more problems than it intended to solve. So let's break this down. We're going to address this from the lens of the Pecor case in the Supreme Court of Canada to provide us with a legal basis. When you add somebody, usually an adult child, to an asset as the joint right of survivorship, you're not just giving them a future gift. You may have intended the strategy as an estate planning hack, but the law sees joint ownership very differently than what you may think. By putting somebody on as the joint right of survivorship, you're literally giving them present legal ownership over the entire asset. And that means if they get sued, your assets may be exposed. So if your family member is involved in a lawsuit of any kind, a divorce proceeding, or becomes bankrupt or insolvent, their creditors can take a look at the jointly owned asset and say, this is yours and we're coming after it. And this is true even if you contributed 100% of the money towards the asset and they contributed nothing. Under joint ownership, it's all the same. Another risk that nobody talks about is the minefield of family law. If you add your child on as a joint with the right of survivorship over assets you own, their spouse may claim that as family assets or family property. Suddenly, all the things that you worked hard for, your investments, your principal residence, or any other property that you own, become bargaining chips in the family law courts. Again, I'm not suggesting that this is legal advice or that they will be successful in suing against the partner. I'm just saying in the realm of possibilities, anything is possible. The third minefield when it comes to joint ownership is that of legal title once the primary owner or the original owner passes away. Was putting that child on as joint with the right of survivorship on that property a true gift? Or was the child added as joint title to save some administration on the estate? This is where the 2007 Supreme Court of Canada case Pecor comes into view. There are two legal considerations that come out of this case. The first one is the presumption of an advancement, and the second is the presumption of a resulting trust. For adult children with the joint right of survivorship over perhaps their parents' property, the law defaults to this position. It is presumed that the adult child who is joint title on their parents' property after their parents' decease is that they're holding it in trust for the estate. Now, this is also absent if there is clear evidence that this was meant to be a gift. In other words, being put on as the joint right of survivor on an asset of your parents doesn't mean that you're rightfully entitled to the gift outright. The courts are going to look for intention, behavior, and evidence. And all three are best proven through written documentation. And if there's any ambiguity at all, litigation and family conflict are soon to follow. Legal costs may skyrocket and estates can get burdened and frozen by the process of court. So let's look at the presumption of advancement. This presumes that adding this person on as joint with the right of survivorship was intended to be a gift. Now, this applies to minor children and spouses, but for adult children, which is typically the case in estate planning scenarios, the presumption of resulting trust dominates. So ironically, the joint owner that you add to the title of the property in order to avoid probate may end up in court trying to prove that they weren't stealing from their siblings. Now look, most Canadians don't realize that the probate monster isn't as big as they think. In Ontario, probate costs are 1.5% of the value of the estate over $50,000. Meanwhile, in British Columbia, those costs are 1.4% over $50,000 plus additional fees and costs. The bigger risk is poor planning that can expose assets to litigation, such as lawsuits or divorces, family disputes, or tax consequences. Saving a few $1,000s in probate may be meaningless if you're exposing your estate to massive legal costs. So here's some tools and ideas that every Canadian should consider and engaging with the legal advice on this when drafting their will or making a gift or adding somebody on as joint right or survivor. Number one, When was the last time you updated your will? And is it properly drafted? Does it do the things you want it to do? Number 2, in provinces where it's applicable, consider drafting a second will for assets that can bypass probate. Where appropriate, consider a trust. Perhaps it's a spousal trust, a testamentary trust, an alter ego trust, a discretionary trust. Number 4, consider insurance strategies that could bypass the estate completely. Number 5, consider reviewing your corporate structure. Number 6, make sure you document letters of intent that clarify which assets are meant to be gifts. And finally, why not make an outright gift while you're alive? Author and speaker John Maxwell says, "Do your giving while you're living so you know where it goes." All of these can help protect the estate, maintain control, avoid unnecessary tax exposure, and keep your family out of court. Joint ownership with the rights of survivorship may feel safe, but simple is not the same as safe. And if you're considering putting a child on real or capital property, make sure you understand the tax and legal consequences. And the absolute key to understanding those consequences is getting the proper advice from certified and qualified professionals such as lawyers, accountants, and estate planners. Just remember that intent matters, documents matter, and good planning matters. If you found this video to be helpful in your journey of discovering the truth about financial literacy, philosophy, economics, politics, and history, make sure you like, subscribe, and hit that notification bell for upcoming videos.